Justice Kagan?
Mr. Buban, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim, and then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
Certainly not the first of the two things I said. I think if you thought that you could have a valid as-applied claim and they had made it through the gate of saying they were a big enough class, then I think consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step, the plaintiff would have it on the first step.
I see. So they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, the court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge Your Honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue and says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.